later on. But for now, we'd like to move to our next presentation, which is Ivano Alogna from BIICL, and he's going to talk on climate change litigation, global perspectives. So it's over to you, Ivano.
Thank you very much. I'm trying to share my screen. Okay.
Yeah, fine.
Thank you very much for the invitation. Thank you to Result. Thank you to all the organizers of the event. It's a real pleasure to be here with you and to participate to what is my first BACL annual seminar. And today I will try and provide a short overview on climate change litigation and its global perspective. So we will see a short introduction of the topic, followed by the presentation of an invaluable tool for its analysis, the climate change litigation databases. Then we will see the different definitions on climate change litigation before analyzing its global perspectives through its comparative and international dimensions and the conclusions. So climate change is considered an always more evident super weak problem. Time is running out, there is no central authority to tackle it, and those seeking to end the problem are also causing it. Notwithstanding the elaborate international climate regime, states are lagging behind in comparison with the rapidity of climate change. The failure by national and international policymakers has required other actors to react in order to tackle climate change. Therefore, climate change litigation is taking the lead in tackling climate change, thanks to suits in which not only NGOs and citizens, but also activist shareholders, investors, cities and states challenge local authorities and national governments' actions or inactions. In this way, climate litigation can be considered as an important component of the governance framework that has emerged to regulate how states respond to climate change at the global, regional, and local levels. Those exerting pressure on the executive and legislative branches of government to act on the climate change issues. At the same time, climate change related cases have also filed against private actors, such as the carbon majors, which are major greenhouse gas emitters, mostly fossil fuel and cement companies. So the climate change litigation database, let's start saying that since its modest beginnings in the early 2000s, literature on climate litigation in law and social sciences has grown steadily. The development of this body of scholarship has largely tracked the exponential growth of the number of climate-related cases. We start from a handful of cases in the 1990s. As of today, there are more than 1,600 cases identified in what you see here, the climate change litigation databases, because there is one for the US and one for non-US jurisdiction and cases. And this is developed by the Sapien Center of Climate Change at Columbia University. It covers 37 countries and 8 regional or international jurisdictions. So we have 1,255 cases, so more than 3/4 of the totals that are identified in the United States alone and thoroughly analyzed by the US climate change litigation database. Then we have the US. After the US, we have Australia, which has the second largest number of climate cases globally. That's why the Center for Resources, Energy and Environmental Law at the University of Melbourne created the Australian Climate Change Litigation Database with 194 cases having been filed. So the second most important. Another important global database is provided by the Grant and Research Institute on Climate Change and Environment at LSE, and is called the Climate Change Laws of the World. It covers both national level climate change laws and policy and climate litigation cases globally. So about the definition, in legal literature, two main approaches dominate the debate on the definition of climate change litigation. On one hand, a narrow definition, according to which climate change litigation only covers litigation which directly and expressly raise an issue that is related to climate change or climate change policy. An example is provided by this often cited definition used by Merkel and Hull. And on the other hand, a broader definitions are increasingly being put forward, which in addition to the explicit reference to the climate change in the proceedings or decision, also consider the motivations of plaintiffs, as well as cases where climate change is not the central, but rather an additional or secondary concern, even when non-expressly mentioned. In this regard, we can see Peel and Lynn's reference. In their view, such a broader definition is especially required when considering climate litigation in the Global South, where a significant, they say, when a significant number of the cases reflect a peripheral focus on climate change rather than having issue at the core of the litigation. So the global perspectives, we can say that the diversity within the climate litigation literature about the definition of the phenomenon under study is in many ways a reflection of the breadth of climate change itself. In fact, the global nature of the problem of excessive greenhouse gas emissions is coupled with the many localized decisions by multiple actors that go toward addressing the issue as part of what we call the global governance of climate change. This global climate governance, besides action taken by international organizations and by states at the legislative and executive levels, is to be considered as encompassing also the role of domestic and international courts and human rights bodies. That's why it appears necessary for a comprehensive analysis of climate change litigation to take into consideration its global perspectives through both its comparative and international dimension. Comparative perspectives. So the last few years have seen significant evolution of the domestic climate change law panorama, as well as the climate change litigation landscape. The advent of global climate protests, you see all this picture, such as Extinction Rebellion or Fridays for Future, has shown a spotlight on the inadequacy of government action and required lawyers to think about how they can use the law to push for change. Among all the cases considered to have flooded the courts, we were saying 1600s, especially domestic courts, several types of climate change litigation have been distinguished. So just to give an overview, there are what we call strategic cases, what the literature calls strategic cases, with a visionary approach, aiming to influence the public and private climate accountability. Then there are the routine cases, which are less visible cases. For example, they deal with planning application or allocation of emission allowances under schemes like the EU ETS, the emission trading system. And we have also another distinction in literature between proactive litigation, which is the one initiated in order to engender policy change, for example, with the adoption of reform of legislation, and reactive legislation, which initiated to resist such change. So the cases, we are starting with the United Kingdom, which by the way is following US and Australia among the countries with the highest number of climate cases. A critical case was one of the most recent, Hervis, Secretary of State for Transport, which concerned the building of a third runway at Heathrow Airport. The court held that the illegality of the third runway at Heathrow was not due to any climate change challenge, the first decision, and the Secretary did not have any obligation to consider Paris Agreement, neither the underlying science of climate change or a more stringent potential future target necessary for meeting the climate change targets. The appeal took place on 21st October 2019, which resulted in an historic judgment on 27 February 2020, ruling that the Paris Agreement ought to have been taken into account by the Secretary of State. So a successful case in this case. Then we have the United States, which has also seen lawsuits on non-statutory issues, such as the famous one, Juliana versus United States, in which 21 young people saw declaration in the federal court that the government had a legal obligation to fight climate change under the public trust doctrine and the US Constitution. Several other lawsuits have been attempted in the US on the basis of this doctrine, but most have been dismissed on the grounds that the doctrine does not apply, that the plaintiff lacks standing to sue, or that the judicial action would interfere with the object of legislative and executive powers. However, its application was initially allowed in the Juliana case, which was object of several appeals by the Trump administration. And unfortunately, the case has been dismissed on 17 January 2020 by the United States Court of Appeal for the Ninth Circuit. On the contrary, looking for a successful climate change litigation case was the landmark Pakistani case of Asghar Leghari. The government of Pakistan was sued by this farmer for failure to implement its 2012 national climate policy and framework. The judge found against the government and established a climate change commission to oversee the proper implementation of the policy. However, we must say that even before the case had been decided, climate change legislation was enacted in Pakistan, showing the influence of the litigation on legislators. Finally, another example of domestic climate litigation is the famous Urgenda case, a landmark decision by the Dutch Supreme Court in which it ordered the national government to reduce its greenhouse gas emissions by a set amount. This is the first time that something like this has occurred in any jurisdiction. On 20 December 2019, the Supreme Court agreed that the Dutch government had violated Article 2 and 8 of the European Convention on Human Rights and upheld the set reduction in greenhouse gas emission by the end of 2020. Recently, in April 2020, Dutch government announced its plan to comply with the ruling. This plan includes reducing the capacity of its remaining coal-fired power station by 75% and implementing a 3 billion euros package of measures to reduce Dutch emission by 2020. So for the international perspective, along with the comparative perspective, there is the always more important role of international climate change litigation. The litigation before international regional courts and tribunals is often necessary to complement the international climate change regime, which is fundamentally limited by political compromise and the weaknesses of mechanisms to review the adequacy of state compliance. International climate change litigation present a number of opportunities to improve the global fight to mitigate climate change. It can successfully raise awareness about climate change and its effects and enhance visibility for affected communities. It can also put pressure on states to do more and result in legislative or policy change. And of course, it can involve cases between states or cases between non-states actors and states, such as those through human rights bodies. An example, two examples, for example, the Torres Strait Islanders case or the Kiribati climate change refugee case before the United Nations Human Rights Committee, which probably which are likely to be treated by the next speaker. So I won't tell more. One of the first international climate case was in 2005. It was a petition before the Inter-American Commission on Human Rights. It provided a full analysis of the possible violation of the Inuit people's human rights if the United States failed to adapt their policy to the mitigation of climate change. The case, unfortunately, was dismissed before even consideration of its admissibility, on the grounds that the claimants had failed to identify concrete acts or omission of the US government that constituted a violation of rights. This was a missed opportunity for the inter-American system to consider the link between climate change and human rights, years before climate change litigation being a well-known strategic legal tool. Traveling on the other side of the Atlantic, a number of climate change cases have been brought before the Court of Justice and the General Court of the European Union, the majority of which have been workhorse cases. However, the People climate case was more ambitious. 10 families from across the EU and other states brought a claim in May 2018, arguing that the EU's climate target of reducing domestic greenhouse gas emission by at least 40% compared to 1990 levels by 2030 was not sufficient to avoid the dangerous effects of climate change and threaten the plaintiffs' fundamental rights to life, health, occupation, and property. The case was dismissed at first instance, with the General Court finding that the families lacked standing for failure to show direct and individual concern. The case was appealed in July 2019 and has divided since then academics on its likelihood of success, particularly due to the difficult task of seeking a review of the Court of Justice rules on standing. We conclude with another quite famous case. It was filed 1 year ago in September 2019 before the UN Committee on the Rights of the Child. It was the first petition on children and climate change brought by 16 children from across the world against Argentina, Brazil, France, Germany, and Turkey. It was accepted and delivered to the respondent states. The relief sought are findings that climate change is a children's rights crisis. The respondent states are recklessly perpetuating this crisis and in doing so are violating children's rights to life, health, and prioritization of the child's best interests, as well as the rights of indigenous children to their culture. Additionally, the petitioner asked to review and amend the national laws to accelerate mitigation and adaptation to climate change, initiate cooperative international action, and ensure that the child rights to be heard by allowing participation of children in these processes. So far, Brazil, France, and Germany responded to the petition, arguing that it was not admissible on 3 grounds. First of all, the committee lacks jurisdiction. The second is the petition is manifestly ill-founded or unsubstantiated. And the third, petitioners have not exhausted domestic remedies. So in May 2020, the petitioner filed a reply asserting that the petition is admissible, arguing that the committee has jurisdiction because the children are directly and forcibly injured by greenhouse gas emission originating in respondents' territory. The second, the claims are manifestly well-founded because the children are suffering direct and personal harms now and will continue to in the foreseeable future. And the last, that pursuing domestic remedies would be futile. So the conclusion, in conclusion, climate change litigation is increasingly being used as a tool to pressure governments to adopt and implement more ambitious climate policies than better align with the national and international obligation, and to hold major greenhouse gas emitting corporations accountable for their climate impacts. The success of such climate litigation in different parts of the world has inspired citizens and NGOs in other countries to try this way of environmental and climate activism, also stimulating the improvement of the climate change laws and regulation. There has been an increase in complaints launched before the United Nations human rights treaty bodies and regional courts, which are becoming interesting laboratories of judicial experimentation as a trigger for more aware states' consciousness in relation to climate change issues. The consciousness of this ecological interdependence among states is triggering the need for dialogue, cooperation, and a legal collective response in order to tackle climate change in an always more effective manner. Thank you for your attention. Sorry if I took more time that was given, and I'm available for answering your question.
Thank you very much, Ivano, for that really interesting presentation. And again, you've showed us all